special provision as to
So
finance.
follows the Delhi model.
Delhi has led
Delhi, of course, 1 and land. 1, 2, and 18 is carved out. Land is given to the state legislature.
No, land is not given.
Not given. Where is land accepted? Which provisions is land taken away?
Not here. Not here. Here only police and public order.
Right.
But in Delhi.
I thought you were saying land is also taken away.
No. In Delhi, it is public order, police.
And 1, 2, and 18.
1, 2, and 18. Your Lordship, sir, Lord, we have troubled your Lordship, sir, for a long period, my Lord, on that. I wanted to avoid that part, my Lord, but it is...
It's argued so many times that even 1, 2, and 18 is stuck like a mantra in the brain, you know, so...
But here, my Lord, 18 is not there, my Lord. It is only public order and police.
Yeah, public order and police.
And for, my Lord, reasons obvious. The very object and purpose of reorganization is this. Well, thereafter, there are financial bills provision.
One more change. Parliament has competence on all the 3 lists.
That is because of 239AA. Not here, it's not there.
So, unlike a state legislature, in the case of union territories like Delhi, for instance, Parliament can enact a legislation on any item.
That is because of 239AA.
AA. But I'm saying the same principle is followed here.
I don't think, my Lord.
It is
here 239
subsection 2. Nothing in subsection 1 shall derogate from the powers conferred on Parliament by the Constitution to make respect to any matter for the union territory.
So, my Lord, that 239AA provision is incorporated in the statute. Your Lordships are right. My Lord, there is a consolidation for consolidated fund, my Lord, which Mr. C.U. Singh said it's taken away. Annual financial statements, audit by the CAG. My Lord, this is a official language, my Lord. For the first time, there is an official language, my Lord. I wish this was pointed out to your Lordships, my Lord, while saying that we have been deprived of everything. It's just a UT. It is a state, my Lord, for all purposes except these 2 entries. Lord, Mr. C.U. Singh argued that the assets are also merged with Union of India.
Actually, nothing turns on it in this case. It's almost like trivia right now. But clause 2 says nothing in subsection 1, 32, shall derogate from the powers conferred on Parliament by the Constitution to make laws with respect to any matter for the Union Territory of Jammu and Kashmir or any part thereof. So this provision does not empower Parliament to make a law on the state list.
Like 239AA.
The provision comes in 246(4). 246(4) says Parliament has power to make laws with respect to any matter for any part of the territory of India not included in a state, notwithstanding that such matter is a matter enumerated in the state list.
No, that is at par with everyone.
That's why, no, just as a matter of constitutional position, Parliament can enact a law on all the 3 lists for Jammu and Kashmir.
Even in absence of subsection 2, it could have.
That's right. That's Article 246(4).
Constitution operates.
That's a constitutional position.
So I am not reading, my Lord. Mr. C.U. Singh, my Lord, said that even the assets will go to has gone to the central government. So there is a specific provision, apportionment of assets. Jammu and Kashmir assets remain with Jammu and Kashmir, and Ladakh assets went to Ladakh. That's how, my Lord, whenever reorganization takes place, the things happen. These are the only petitions and these are the only grounds in those petitions. The Lordships are aware, my Lord, how a constitutional act of imposition of governor's rule or president's rule is to be challenged, and what should be the averments. What was the material, sufficiency, this, that, another? Nothing. Because it was done after 14 months, only as a corollary of challenging 5th and 6th of August action. I'm not reading, my Lord, the pleadings, but there are no pleadings. My Lord, that's all I am saying. Lord, I'm going fast. I've seen your Lordship's eyes looking at the clock, my Lord. I am also on the clock.
No, that's not. Please don't have any such feeling.
On the lighter side, but it's
that eye goes to the clock just as a matter of training. You know, that's all.
On the lighter side, what I am saying, so that
not directed to the attorney also. More than 22 years of training on this.
Exactly, more than 22 years of training. Mr. Solicitor, when we were judges of the Bombay High Court, we had a colleague who had come from Gujarat on transfer, a God's good person. So he had this specialization. We would meet outside the Chief Justice's chamber every morning. Just a little bit of camaraderie, and then we go to So every day, our colleague who had come from Gujarat would tell us how many more days there are to go back to the vacation.
Yes.
So,
But it is
there are
said that
66 days left for the vacation.
but it is like many other parts, Lord, it is said that a Gujarati can come out of Gujarat. Gujarat never comes out of him. we always.
You are right, Mr. Attorney General. You are right in Mr. Attorney General to the point that this was an aid of constitutional integration.
Yes.
And as we see that integration was taking place by and by from 1957 right through to 2019. So subjects which were completely excluded to the Parliament were brought in within the purview of Parliament. That was also a clear understanding of the constitutional movement towards greater integration of Jammu and Kashmir into the Republic of India and the Dominion of India originally, and the Republic of India. So there was undoubtedly a gradual and imperceptible integration, apart from the unconditional accession to India, which we saw right at the outset in Article 3. There's no difficulty about that. But the only point really is this, that there are two ways of looking at Article 373. If the proviso can't apply, we keep 367 apart for a moment. If the proviso to Article 373 cannot apply, does that mean that the power under the substantive part of 370 is completely denuded or lost?
No. The answer
and if that power is not lost, is it a unilateral power then which can be exercised by the president? What Parliament really did was this. They didn't have a constituent assembly in the state of Jammu and Kashmir. There was no constituent assembly. They were exercising this power to abrogate. They followed the 367 course, obviously, with an idea that in the absence of a constituent assembly, there's no legislative assembly in the state. You go to Parliament, which in that sense represents the broad diversity of
the decision.
You have the Rajya Sabha, which is the Council of States, which represents the overall diversity of the nation. You have the Lok Sabha, which consists of elected representatives of the nation. But in that process, there's one, I wouldn't say casualty, but one dilution. And that dilution is the role which was ascribed by the proviso to Article 370(3). Now, that role can, as you are trying to elaborate, that role is merely recommendatory. Merely because that role is recommendatory does not mean that it can be dispensed with, because the Constitution provides for a recommendation. When a Constitution provides for a recommendation, we can't say that, well, even if there's no recommendation, that's fine, you can override it.
My endeavor is...
Can I just add one thing? Sorry to interrupt. You see, after you amend 367 and say legislative assembly is equal to constituent assembly, we have to take it to the logical conclusion.
Right. We've accepted that it exists, but
that's right. That's how it is.
But my lord, only one question, my lord, and your lordships can consider this, my lord, during this holiday. My lord, suppose in 1957, at the time when the Constitution was framed, Constitution of Jammu and Kashmir,
yes,
and the Constituent Assembly was dissolving itself, last speeches were made, etc. Suppose it would have said that now, in exercise of our powers under 370, sub-article 3, we recommend the president that the constitution which we have framed will provide for a semi kind of monarchy, and now therefore you delete 370. Lord, would it not go against the very spirit with which 370 was incorporated? That it has to be temporary and you are an integral part, because 370 sub-article 3 says, notwithstanding anything contained in the foregoing provision, meaning thereby 1 and 2, instrument of accession and Article 1 being applicable. So, Constituent Assembly technically was not bound by 1 and 2. It could have said, then, my lord, would the president be completely denuded and act as per the desire of the Constituent Assembly? It cannot be, for the simple reason that the debates in the Constituent Assembly repeatedly say that this is a temporary provision.
So that's why I said you can't.
You don't have to refer to the debates.
So that's why I said there can't be a negation principle read into the proviso. A principle of negation whittling down the entire scheme of Article 370. You can't read it into the proviso.
Let us say, bro, that as Sheikh Abdullah at that time wanted, bro, that independence resolution being passed. That's why you put an register of the assembly.
Mr. Deveri, that answer is given in the Article 378.
I'm saying, had they proposed, then the president is not bound.
No, that proposal is not, this will be contrary to Article 378.
That's right.
May I have your lordship's permission in support of this submission?
Contrary to Article 1 also.
Reading material can be shared with.
Kashmir is an integral part of it.
That's all right.
Question.
Some reading material can be shared with your lordships, and then
No, nothing in terms of reading material, Mr. Attorney.
We have enough reading material with us.
Now we will go by churning material, which we have at the bar.
I didn't want
Because
to.
then in rejoinder, we'll get a couple of thousand pages, Mr. Attorney, and we only know what difficulty that poses at the end to us.
Coming through that, I understand.
Give you a more accurate list of names.
These are some.
We put that discipline on you because we realized what would happen.
No, but what happened?
That was.
No.
So the facts which are on record in the work of Sardar Patel.
This is please let us not get into that. I don't think.
says.
I don't-
Sibal,
I don't-
you'll have your chance in the
I
second
don't
round.
think this statement is necessary at all. No, the reading material is some excerpt from certain books. Some thoughts come in the course of how do you explain internal sovereignty? How do you explain certain? I thought if they are useful, I can certainly.
One last word, and then we'll rise, of course, then we'll think of all that you've argued for the holiday tomorrow. That the wide chasm between absolute autonomy as it existed on the 26th of January 1950, all right, and complete integration as it was brought about on 5th of August 2019, that chasm had been substantially bridged by what was happening in between. So really, in the sense, it was not a complete migration from absolute autonomy to absolute integration.
It had become a shell, my lord, as
Whether you call it a shell or not,
Gujarilal Nanda said. my lord,
it's obvious that a substantial degree of integration had already taken place in the last, between 1950 and 2009, 69 years.
The final
And therefore, what was done in 2019, was it really a logical step forward to achieve that integration?
Absolutely.